we had kicked around the idea of sports law, and Bob Wallace, who joined our panel at USA&M, put together a great panel for this program. Bob's a partner at the Thompson Coburn firm, has spent his entire career focused on sports law, initially getting his start with the former St. Louis football Cardinals, worked also in the NFL for the Eagles and the former St. Louis Rams. Bob's going to kick off this program and introduce our other panelists. Bob?
Thank you, Rob. Thank you, USA&M, for hosting this and inviting us to participate. So many of you have followed teams or players, leagues or sports, and we talk about sports law. Many ask, what is that? Well, there really is no such thing. Sports and the law is more appropriate. Matters that affect sports entities are the same matters that come into play in other businesses that you represent or do work with. Included in those matters are how entities, and in this space, sports entities, deal with disputes among and between the employees, partners, and players. Today, joining me on this panel are two well-known and respected practitioners in sports and the law, arbitration, and alternate dispute resolutions. They are Bob Lattenville and Hal Welford. Bob Lattenville from the William Morris Endeavor firm, entertainment conglomerate, let me put it better that way, has represented sports executives, including me, college athletic administrators, coaches, and players for over 30 years. He has been involved in several high-profile sports arbitrations, and he is going to talk a little about the arbitration process and how he thinks about that when negotiating contracts and how he goes about preparing for those arbitrations. Hal Welford from Little Mendelson has focused on employment litigation and client counseling for more than 30 years. He is also well known in St. Louis for representing the St. Louis Blues and the St. Louis Cardinals in contract negotiations and salary arbitrations. Hal is going to walk us through MLB salary arbitration process. I'm Bob Wallace from Thompson Coburn. I'm a 40-year NFL and sports executive and lawyer, having worked for the St. Louis Cardinals, Philadelphia Eagles, and St. Louis Rams, as Rob mentioned. I have negotiated player and coaching contracts, tried several arbitration matters, and served as an NFL hearing and arbitration officer. I'm a member of USA&M, and I'm going to talk about the NFL's various arbitration processes. After we go through our presentation, I anticipate we will have some time for questions and answers. So please go to the chat room and submit those questions that you may have. And after that, we can have sort of a conversation if enough topics are raised. So Bob, I'm going to turn it over to you and have you go through your presentation.
Very good. Thank you, Bob. Good morning, everyone. I'm going to provide an overview of arbitration considerations. And I will note that my background is as a corporate attorney. And my first involvement with regard to arbitrations was typically as an expert with regard to value. I'd provide a salary range for a coach, whether it be an NFL coach or a college coach. And often enough in sports, whether or not you arbitrate is predetermined. So for example, the National Football League and its union, the NFL Players Association, they've already collectively bargained for an on-field code of conduct as well as an off-field code of conduct. And it's got a well-defined schedule of infractions and fines. So for example, if you represent a player that was flagged for a late hit and that late hit was targeting, there will be a hearing on that conducted pursuant to pre-prescribed rules that the NFL and its Players Association have already agreed on. And there will be a cache of information that's available, including video, to try to determine whether or not this particular infraction was in fact something that would draw a fine and what the range should be. And so that's one circumstance, and it's not uncommon in sports. Same thing when I represent employees, mostly, whether it be an agent or a coach. Usually, if there is some sort of dispute resolution procedure, it's already predetermined. So for example, if I represent an agent in a dispute against another agent, trying to determine whether or not one agent tortiously interfered with his relationship with his NFL player. The NFL Players Association has its own code of conduct. And in that code of conduct, there is a prescribed arbitration procedure. And so often enough, probably more than half the time, I'm working in a circumstance where arbitration is required. And the arbitrators that we're dealing with are seasoned veterans. In the NFL, for example, the arbitrator there, Roger Kaplan, has been there. Bob Wallace probably knows, but I'd say close to 40 years. And so that's a wholly different circumstance than the considerations that I want to discuss right now. What I'm discussing, again, from a corporate law standpoint, is when you're in the process of completing your employment agreement and you have the option for dispute resolution, why might you choose arbitration over litigation? Why would that be helpful to you? And I'll run through a handful of points that I consider with regard to arbitration versus litigation. And in the materials, I've outlined those, including what I'll note as templates for various issues to be addressed. Okay.
Can you advance his slides?
Yeah, perfect, Bob. Thank you. Okay, so let's talk about the first one, and that's a decision maker with industry experience. And I certainly don't mean to give short shrift to a judge in this particular circumstance, but I think it can be particularly helpful in the employment area to have dispute resolution accomplished by someone that is very familiar and well versed in the area. And you may have a brilliant judge, but if she or he has never done a sports arbitration before, it take a little bit longer to get the tribunal, whether in this case a court, perhaps even a jury, up to speed. That takes time and it costs money. And so that's another benefit, I think, of arbitration. Typically, it can be more expeditious, and I say that typically. The second part, though, and I don't think speed or cost is the next most important one to me. The most important one to me is confidentiality. Oftentimes in an employment situation, there are sensitive matters that are being addressed. And the benefits of arbitration, if they're properly drafted in the employment agreement, are confidentiality. And I can tell you an aside, but it's one worth talking about, is I had a case with a very prominent individual versus a very prominent employer. And the arbitration provision was clumsily drafted. It was maybe 7 or 8 sentences. And one of those sentences indicated that the parties agreed to resolve any disputes pertaining to this agreement pursuant to confidential arbitration in St. Louis, Missouri. Well, it begged the question, and it was a very expensive one to address, as to whether or not confidential arbitration just pertained to the proceeding or whether or not it actually pertained to the award. And in this particular case, and I'll talk about it now and then probably later on, that issue was really a seminal issue in this case because the reputations of both these high-profile individuals and the institution were at stake, along with tens of millions of dollars. Long story short, the arbitrator determined that the proceeding was confidential, but the award itself was not. So when we had gotten actually to the 4th supplemental opinion and award, there were 6 in total, which lasted over 7 years. But when we got the 4th supplemental opinion and award, the employer sought recourse to the courts to try to have it overturned. Well, it was a bold and gutsy move by them, and they were the party that was most concerned about confidentiality. But when they did so, the Eastern District here in Missouri determines, like, look, you can't avail yourselves of the court system and not be subject to all of its requirements, including the transparency of a public forum. So what ended up happening is when they filed their complaint, they necessarily had to file all of the awards with it. So the original awards and then 4 others. And so consequently, all of the information, most of the details that they didn't want to get out, was already brought to light. And so that was an issue that we spent millions of dollars litigating, but ultimately it was a circumstance that was of no matter. And at the time I was representing the employee, and it was a great situation that essentially broke the case wide open. But I would tell you the importance of confidentiality is critical. And it has to be something that you include in your agreement. And we've all learned in the last year or so, there's no such thing as boilerplate. if you want to do a force majeure clause anymore, that may be the most heavily negotiated provision in your employment agreement. And I would suggest to you that the arbitration provision should be equally well considered. Confidentiality, a key point. Remember it. I've got a provision in there that I think is a decent starting point for your practice. Speed, number 3. I think that's important. Time is money, and it's cliche, but there's a reason why it's cliche. Typically, an arbitration moves more quickly than litigation. That's not always the case. And I would tell you again, harking back to that case that we discussed, the petition was filed for arbitration in February of 2015. There was an award that was received in July of 16. As I indicated, there were 6 supplemental opinions and awards. And of course, there was a briefing schedule that accompanied all of those things, including an original brief, a response, a reply to that, and any number of SIR replies that kept this case live all the way until January of this year. So filed in February of 15 and finally concluded in January of 2021. Do I think that's an aberration? Absolutely, I do. But one thing to think about is, and I would suggest this, given the ambitious schedules of our judges, sometimes that promotes efficiency. It's like, look, we don't have time to go back and forth with this. I want your best shot. I want it now. Give it to me. I'm going to make a decision. And arbitration being a much more equitable forum, or typically more equitable forum, the tribunal is also more likely to give leniency with regard to information or a point of view that a counselor might not have been able to deliver the first time around. There's much more tolerance for that, and you might find that very, very helpful. But it's also costly, and it's costly because it takes time, which gets me to my next factor. Overall, the cost of arbitration, at least in my experience, is a fraction of what litigation is. However, you've got to remember that arbitrators, unlike our great judges, get paid. And sometimes, particularly with regard to an experienced arbitrator, that may be as much as $3,000 to $5,000 a day. We know, and I think about an arbitration, it's not at all, in my opinion, like a mediation in terms of time. Most of the time, if you have a mediation, which I strongly recommend, and I'll talk about in a minute, in advance of an arbitration, is you'll get a resolution that day. At least you'll find out, are we going to agree, or are we going to agree to disagree, and then move forward. With regard to an arbitration, oftentimes you might have a hearing. In the one case I described earlier, it was 15 days of hearings. And then, of course, every time you file something, the arbitrator has to take a look at it. And his fee at the time was similar to what attorneys were getting paid, $500 an hour or so. And our arbitration fees for that particular arbitrator, who did a wonderful job, approached $1 million. So I would tell you, that's something to remember. The arbitrator gets paid, and that's part of the process. So speed's important, costs important. I like particularly as a corporate lawyer, I like the procedural flexibility that the arbitration provides. And I would say this, there are just some benefits to not having to lay a foundation to every piece of evidence that you include in there. And an arbitrator that's familiar with your issue and the law will understand its relevance and be able to quickly identify as to whether or not a particular witness or a particular piece of information should be admissible. Okay. And then lastly, I would say this, particularly with regard to sports, based on my experience, and again, this is coming from a corporate lawyer, I've received, and my clients more importantly received, more predictable results in arbitration than they have in court. And most of that is a result of when there's a jury trial. And so, as you might imagine, oftentimes the employee will prefer that circumstance because there may be some emotional advantage that they gain. But I would tell you this, when I'm representing a coach or an agent or an athlete, I prefer a much more dispassionate award as opposed to an emotional verdict based upon, and it might just be scale. I've been in court often enough when they'll talk about, for example, the average monthly wage of a defensive coordinator in the National Football League, and what opportunity costs were compromised as a result of the position that the employer took, whatever it may be. And eyes light up. And at that point, I'm concerned that the jurors like, I've lost them at that point, because they can't equate why someone who with a card in front of them calls defensive plays makes twice as much as their heart surgeon. And at that point, I can never get them back on. It's like, forget the zeros. Here's the issue. And so I would tell you that in sports arbitration, I much prefer that dispassionate award. Okay. So challenges of arbitration is not automatically enforceable. One thing I want you all to think about with regard to an arbitration is this. They're not effectuated immediately, it's like as, for example, an order would be that comes down from a court. So often enough, even if, let's say, for example, I award Bob Wallace $1 million payable by Bob Lattenville within a week, and there's nothing else in there except that, people recognize that Bob Wallace beat Bob Lattenville in that particular circumstance, and Bob's got every right to file that and confirm it if he wants to. So as you're drafting your provisions, you need to be mindful of that, is like just who won or who lost may be critically important in that circumstance. And then finally, I'll just note that typically there are not appeal rights in an arbitration, although you can bake them in. You can put it right into your employment agreement if you choose to, or it may be something that you agree upon later. But I would tell you this, to the extent that you make the arbitration process resemble much more of the litigation process, really what have you advantaged yourselves? And that may be the case. You may consider that it's worthwhile doing, but I would suggest to you that it probably defeats the purpose unless your primary goal, and it's a worthy one, is to have someone involved in your arbitration that is expert in the issues and can get you an answer sooner rather than later. Okay, so let me just take a couple minutes to talk about mediation. I think mediation in advance of arbitration is a wonderful tool. And I will tell you why. It seems to me, particularly at the beginning of a dust-up, that both parties are polarized because they're primarily, in my opinion, unrealistic. Many of the facts that they point to as having merit or incapable of being overcome by the other side are absolutely irrelevant. And I don't mean to poke at the plaintiff's bar, but often enough, there's a business component, obviously, to everything that we do. And promoting the fact that they have a case might blind them to the fact that there's a whole host of defenses that they never really considered. And so I love the idea early at the onset that there is a neutral third party that brings people back to earth. Okay, at the end of the day, what are we talking about? Let's get it down to the point where we understand what the issues are and we recognize what the scale is. What is the magnitude of this problem, as opposed to a host of what I'll suggest is hyperbole that really doesn't advantage anyone. I think that's particularly helpful with regard to mediation. So I like the issue framing component of it. It needs to be confidential, and you need to write that into your particular provisions there. And then I like the fact that there's not a third-party resolution. If you want predictable results, then negotiate for them, and I think that's helpful. So again, a non-binding mediation, I think, is a worthwhile process. Some of the suggestions I have with regard to its drafting, and I'll be brief, I don't want to run into Hal's time, he's infinitely more interesting than me, is this. You've got to include deadlines in your mediation. Otherwise, it can be used as a delay tool. Okay, so put deadlines in there. I think you need to make it mandatory that they participate. Obviously, include your confidentiality provisions for sure. Note perhaps that you need a tolling of the statute of limitations. And then last but not least, bring somebody there, require that they bring somebody there that actually has settlement authority, because otherwise they've always got plausible deniability. It's like, look, if we're trying to get a resolution done, let's get everybody in the room that can get a resolution done. Otherwise, we're wasting our time. So, okay. Now, if I'm drafting an arbitration provision and I've gone through those considerations and I've identified that overall, I'm better off with an arbitration. And again, this is in the circumstance where you get to draft it as opposed to some sort of requirement under a collective bargaining agreement or a code of conduct. Here's the things that I think that you need to have in there. If you identify, as I do, the benefits of having a qualified arbitrator, then put them in there. Okay, I want an employment lawyer with 10 years of experience, whatever it may be. Or if I'm a construction lawyer or intellectual property lawyer, whatever it may be, but identify what you want. Perhaps you want a little bit more what I'll suggest is structure. So maybe you want a retired judge who's got practice as a lawyer first, but also as a judge, so that he or she will impose maybe more strict guidelines in terms of procedure, whatever it may be. But think about what's important to you and negotiate that. And you say, well, gosh, most of the time, when I get to the arbitration provision, I consider it about the same level of importance as I used to consider force majeure and all those other things. The time you spend, even if it's a couple hours doing it at $500 or more an hour, is well worth it when you get to the point where you actually have to use the arbitration provision. So put the arbitrator's qualifications in there. Note how you will appoint him or her. Now, most of the services, whether it's AAA or JAMS, they have provisions in there. I kind of like establishing a pool based upon the qualifications and then having a strike process. I think that's a worthwhile and efficient method. Again,
We're trying to add USA&M to those services that you use too.
I'm sorry, Bob.
We're trying to add USA&M to those services that one might use for alternate dispute resolution.
Oh, terrific. Okay, yeah, terrific. And I would say just on that, a practitioner's point, I like using AAA, not necessarily to the exclusion of JAMS, but one of the reasons why I like using AAA is it gets back to that first point. A decision maker with industry experience. There's just more AAA arbitrators out there. I can't quote you the numbers. I think it's about 5,000 than there are JAMS. And JAMS used to be primarily judges. Now they've allowed retired attorneys in there. But I want to say it's probably 10 to 1. I think that there's probably only 400 or so JAMS arbitrators out there, or mediators. St. Louis actually has a JAMS office, and I've used them, and they've been great. But I do think if you're looking for more options in terms of the experience of your arbitrator, I prefer and defer to AAA. Okay, so you got the qualifications, the appointment, the confidentiality. Obviously, put governing law in there. I think venue is particularly important. I had the very, very good fortune back in '98 of our law firm to work for Mark McGuire. And in that summer, he and Sammy Sosa were, it was can't miss TV. I don't know if we're all St. Louisans, but if you remember, if you're old enough to remember, that, every time he got up to plate, people held their breath. And so I just recognized that to the extent I didn't do my best lawyering on the deal points, if I had venue in St. Louis, Missouri, particularly if it was a non-arbitration matter, I like that was critically important. I couldn't imagine having a better client than perhaps representing the Pope in Vatican City. It was great. That provision carried the day if we ever had a dust up. So venue is important. Procedure for confirming the award, I think, is important. And then I always like to have a prevailing parties provision in there. I think it keeps everyone honest. And as we all know, if you don't have it in there, it's very unlikely, unless you have a statute or contractual provision, to be awarded attorney's fees. So think about all those things when you draft your arbitration provision, and don't consider it boilerplate, because it's not. Thanks, Bob.
Thank you, Bob, very much. We had one question that, talking about confidentiality, could you have written in your agreement that you were going to seal the award, whatever the award was? Is that possible too?
Yeah, absolutely. I would have put that in there. Yeah. And so you'll note in the my eyesight's so bad, but it's on the screen. If you'll note in there that there is a requirement that the procedure as well as the award be confidential, and then whatever you do file has to be limited to getting the relief that you seek. But I think that's a great idea to note that it has to be sealed. The one thing I would, and if you have agreement on that shouldn't be a problem. But in our case, forgive the digression, but I think it's worthy. There was no such agreement with regard to that. And the judge, I believe correctly because I represented the other side, but I do think it's like, look, you availed yourself for the courts, and along with it comes the transparency that the courts provide. And so again, it was a several million dollar issue that came back to bite the defendant in this circumstance.
Thank you, Bob. Hal, you want to talk a little bit about baseball arbitration and your practice there? Are you on mute, Hal?
There you go.
There we go. Want to thank USA&M for hosting us and for everyone attending. I actually prefer USA&M over AAA for what it's worth. Being bigger is not always better, I've found in arbitration. But the baseball salary arbitration process is unique to any of the other arbitration processes in which I have participated. The process is all in the collective bargaining agreement between the Major League Baseball Players Association and Major League Baseball. It dates back to 1973, 1974. For those of us who can remember the reserve clause and the times when players were basically required to stay with their clubs and there was no free agency, no salary arbitration. That changed in 1974. The process is, it's about 3 or 4 pages in the collective bargaining agreement. It provides that players between 3 and 6 years of major league service, and major league service is actual time spent on the big league team. So those who follow the Cardinals and the shuttling of players up and down in the minor leagues, that is a flexibility that the team needs, but it's also a way to keep a player's MLS from accruing. And this has been an issue with the players, specifically when a rookie has a great spring training, but the club doesn't want to bring the player up because their clock starts ticking. That was a situation that occurred with Albert Pujols back when he came along with the Cardinals, and it was highly unlikely that he was going to make the roster, even though he was maybe the best player on the team in spring training, because the club didn't want to start his clock, but he was so good that the club did bring him up. So players between 3 and 6 years of major league service, if they and the club cannot agree on a salary, they're eligible to participate in the process. Players with over 6 years of MLS are eligible to participate in the process, which I'll describe. Very rare that occurs. It did occur in 2012. David Ortiz decided to go through the salary arbitration process, and he probably did better in the salary arbitration process than he would have in free agency, but that's highly unusual. The process begins in mid-January each year. The players submit what they believe is the appropriate salary for them for their relative MLS. Say a third year MLS would be the first year you're salary arbitration eligible. The club does not know what the player's number is. There's a lot of discussion, obviously, before figures are exchanged. And we know generally where the player will land, but we don't know what number the player has submitted. We have 10 days to submit our number. The numbers are then exchanged on January 15th. And the Players Association and Major League Baseball then decide to assign these cases to a panel. The panels are consisted of 3 arbitrators. In the early iterations of the collective bargaining agreement, it was 1 arbitrator per case. But what the owners found is that the arbitrators really like this work. They're well compensated. It's interesting. The cases are interesting. And there was a possession arrow problem. So if you had a case, very strong case, but an arbitrator had ruled for the club in the 2 previous cases that she had heard, even though you had a very good case, there was a concern that you were going to lose that case because the arbitrator wanted to remain on the panel if it was a close call. So 15 years ago, ownership was able to change the process to give it a 3-panel hearing process, as opposed to just 1 arbitrator to to address this possession arrow. The hearings take place in February, and once you're assigned a date, it's a firm date. There are both sides appear. There are experts that appear. The player usually always appears. Generally, someone from management appears. You'll have your data experts on each side will both be there. It's an hour and a half per side, and it's ambush. The other side doesn't know what you're going to argue. We don't know what the player is going to argue. We give our submission to the panel as we begin the hearing. The player goes first and goes through their presentation. As in any good presentation, you try not to read from the presentation, but direct the panel toward the significant exhibits that you believe turn in your favor. It's really all about trying to tie the player's number and the club's number. Hopefully the club's number is closer to salaries that have been paid for similar 3 MLS players in the past. There are differentiations between positions. Obviously, third basemen make more than shortstops and second basemen. So you really look for a group of players over the past 3 years and analyze what the salary has been for that player and what their performance has been. There's no discovery. Again, it's ambush, and you go in trying to anticipate what the other side will argue. You are given a 15-minute rebuttal after each side is prepared their submission. And now we feverishly put together a rebuttal of everything that we didn't put in the original submission that we weren't sure the other side was going to use, or we scramble to try to rebut something that the other side has raised that we think deserves to be focused upon. There's no written opinion. Arbitrators love that, I'm sure. And the decision is within 24 hours of the hearing. The hearing begins when I give the panel 2 contracts signed by the club, and they fill in the number. And that's the result that you get. You get notification that the panel picked a particular number. Each year, the Player Association and Major League Baseball choose the arbitrators. It's unusual that the panel changes. They're very high reputation arbitrators on these panels. And as this situation has been going on now for almost 50 years, the arbitrators have developed an expertise in baseball and in analytics. So what are the criteria that are utilized? They're again set forth in the collective bargaining agreement. Probably the 2 most important are the quality of the player's contribution. And that can be looked at through a number of different lenses. Did they win a Gold Glove? Did they, were they an all-star? That type of thing. Those are important. And then number D, or letter D, the comparative baseball salaries. That's what I referenced when we're trying to figure out and argue a case, and baseball arbitration precedents is this list, this history of what comparable players have earned in the past. And so there's almost a history, precedence based on what's happened in the past, and you have to know what all those numbers are, and you search pretty diligently to find those nuggets of comparable salaries. And of course, you look at those comparable salaries when you are setting your bid back in January, what you think the player's going to want and what number we're going to put down as the number in the salary arbitration. And it's a number what you have to be able to save some money off of what you think the player is worth, but you also have to submit a reasonable number, because this is final offer arbitration. There's no splitting the baby. The arbitrator selects either the player's number or our number. And so one of the impacts of this is it does bring the parties closer when they make their final submissions. Interestingly enough, if you look at letter F, the arbitrator can look at how well the team has done, and the Cardinals' performance has always been something that I expected that would be used against us. It really hasn't. I think it potentially it could be in the criteria and attendance, but you can't look at the value of the franchise, which is kind of crazy to me. So what the Cardinals pay their player is going to be the same as the Dodgers, the Yankees, the Mets, all of these large market franchises. The process has evolved. In the 1990s, it was extremely robust. We had 24 cases back then. There's been a marked decline in the use of the process over the last, say, 5 years. That's changed in the last 2 years, but in the mid 2010s up to 2018, there actually 1 year there was one year we had no cases. Why is that occurring? Well, number one, the clubs have adopted, many of them, a file and trial approach, which is, this is our number and we're not going to negotiate off of it. We're not going to go to the midpoint. So if Albert Pujols, back when we did his arbitration, his number was 11 million and our number was 4, we're not going to settle in the middle. There's going to be a $7 million gap. We're going to go to arbitration. Well, we did settle the Albert Pujols case, as you know. And how did we do that? Through a multi-year contract. So the advent of more multi-year contracts has eliminated a lot of arbitration hearings. There's also animosity caused by these hearings because someone, the lawyers, are saying something bad about the player, and that's never good for the product. It's not really good. No one really likes it, especially the clubs. And the conservative approach of both sides right now, you lose one of these cases, and let's say from a player's perspective, they never get that money back, really. If there's a $2 million difference between salaries, between a 4 MLS player and the club, the player's never going to get it back. Similarly, the club is never going to get that back, and the club may not be able to sign the player to a multi-year contract. That happened back in 2018 when Mookie Betts was in arbitration the first time, and the club submitted a figure of 7 million for Mookie, and the player submitted a figure of 10.5 million. And they went to arbitration, and Mookie won. Mookie Betts won. And that impacted the Red Sox ability to sign him to a multi-year contract, that $3.5 million gulf. They couldn't get to an average annual value on a multi-year contract. And subsequently, Mookie Betts was traded to the Dodgers and wins a World Series for the Dodgers. Right now, salary arbitration applies to players between really 3 years, although there's a recognition of Super 2 players who have the highest seniority, top 16% seniority within 2 years. They're also treated as 3 MLS. The role of Major League Baseball and the Players Association in the development of these cases is huge. It's not just the club. Major League Baseball is heavily involved in helping develop the arguments, the briefs. Similarly, as Bob would probably tell you, the Players Association exerts a lot of control over the agents. So as I talked about, the process has reached an apex in 1985. It then hit a trough, and the number in 2018 was 22. I think we had 15 last year. So it is becoming more popular. It is a process that the players prize because it has driven up salaries in Major League Baseball. And the process is really being driven by analytics. It's being driven by the MBAs in baseball and on the agents side, who have converted this process into just an argument over a player's batting average to using big data analytics, such as independent fielding value. Those types of statistics have become more and more the realm of the throne in these arbitrations. They're much more sophisticated than they were back when I started, when we were just arguing about who should be paid more, someone who gets saves or someone who gets holds. And the arbitrators didn't even know the difference early on in the game, but now they do. So where are we going with baseball and the law? And I thought put this slide together to kind of compare what we're doing in Major League Baseball as far as salary arbitration and how it compares to the legal system. And I think in Major League salary arbitration, you're starting to see that expertise is more important than experience. Lawyers who have expertise in data analytics and front office people and agents are more effective, and you see more of them in these high profile cases. Bob mentioned the role of mediation. There's no mediation in salary arbitration, and we're in the midst of a new collective bargaining agreement. And I personally think it would be something that I know is being discussed. Whether it's adopted is questionable. The process works so quickly. As I noted, the figures are exchanged in January and the hearings occur in February. So Bob's goal of a quick decision certainly occurs in this context, and query whether there would be time for mediation. But certainly mediation would allow the parties to meet in the middle more readily than to go to a really final offer process, which the salary arbitration process is right now. So what's the future of salary arbitration in baseball? I'd be happy to answer any questions if we end up having any time. Collective bargaining agreement is expiring on December the 1st. Major League Baseball wants to eliminate salary arbitration. They want to create a pool of money and use an analytic approach that can value the contributions of a player across StatCast and all types of other high data analytics. And they would like to also propose earlier free agency. Right now, you can be a free agent after 6 years, but you may not reach free agency until you're 30 years old, 31 years old. Under the Major League Baseball proposal, you can reach it at age 29. You can maybe have 2, maybe 3 big contracts, or if you're Jason Verlander, 5 big contracts. The MLBPA looks at any type of suggestion of a cap as an anathema. And so I would predict that salary arbitration will stay in some type of part of the collective bargaining agreement. And the 29 and a half year old doesn't help the superstars like Vlad Guerrero. So that's kind of where we are on salary arbitration. Again, thank you for letting me speak with such a great group and to be part of a great panel. And if we have time for questions, happy to answer them. And I'll send it over to Bob.
Great. Thank you, Hal. That's really very interesting. And I'm going to run through my brief part of this so we can get some questions. So if you have any questions for Bob or for Hal, please send them to the chat room and we'll get them read. I think we only probably have about 5 minutes, Rob. Is that correct?
That's right. Thank you, Bob.
Okay. Yeah, so we're gonna, I just want to, and salary arbitration provision in Major League Baseball, as Hal said, appears in their collective bargaining agreement. And all of the collective bargaining agreements, at least in the 4 or 5 major sports, and now that we have a soccer team in St. Louis, I now refer to us with 5 major sports, have provisions for dealing with disputes among their employees or even among their partners. So in the NFL and Major League Baseball and soccer and hockey, there's a collective bargaining agreement. And all those collective bargaining agreements provide for some sort of mechanism to determine disputes among them. And all of the leagues also have a constitution and bylaws, or a governing agreement, as it may be referred to, which sort of deals with disputes between partners, owners of the various teams. And that's how they determine disputes. And everybody wants to stay out of court as much as possible and prefer to deal with these in an arbitration procedure. Although what happens is that sometimes one of the sides, whether it's either the player side or the management side, or even if it's among owners, doesn't like the result they're getting, and then they want to go to court. So even though there's a provision for arbitration, it often spills into court. If you look at the Al Davis case and the Raider case, as you look in what may happen in the Rams case, when I guess there's some indication that Stan Kroenke doesn't want to honor his what the indemnity clause that he provided to the owners. Will that become a lawsuit, or will they try to deal with that through arbitration? But as I said, the collective bargaining agreement, if you look, we have 4 or 5 ways to deal with grievances and arbitrations among players. One is the injury grievance. In the NFL, unlike Major League Baseball or even and basketball, the multi-year contract is a misnomer. Mainly, they're a series of 1-year contracts. Over time, it's changed a little bit, and players are getting a little bit more guarantees in the NFL. But the standard rule is that you cannot cut a player while he's injured. So what happens is that players claim that they're injured, teams claim that they're healthy, and there's an injury dispute over that. Usually you don't find that among superstars. You really find that among aging players, or you find out about up-and-coming players, young players that don't have a lot of leverage, and whether they were terminated from their contract based upon being injured. There are also non-injury grievances, which is another provision. These are much more systematic, a dispute over a provision in a contract, over an interpretation of a rule. There are system challenges to it. The collective bargaining agreement, and there are system arbitrators. These are big things. Whether a player is, as Hal mentioned, in baseball arbitration, shortstops make less money than third basemen. Well, defensive ends that rush the passer and knock them down make a lot more money than a linebacker who may only do that occasionally and drops back in coverage. He doesn't have the same kind of stats. So they all want to, if they're edge rushing linebackers, they want to be classified as defensive ends because they can make more money. You seen the same thing between tight ends and wide receivers. Wide receivers make much more money than tight ends, so they want to be. So even though they're classified as a tight end, they split out wide, and Jimmy Graham, Gronk, all those people would rather be just referred to as receivers than that. I for years was a steroid and related substance arbitrator. The simple rule in the NFL is that if you are responsible for what you put in your body, so if you put in your body something that is on a prohibited list, that you can be suspended. When I did it, one of the things I found very interesting was that Adderall was the big prohibited substance. And players would say, well, I didn't, I was having trouble staying awake, and it was classified as a performance enhancing substance. I was having trouble staying awake in meetings, so I took Adderall to help me stay awake. Well, to me, that was a definition of performance enhancing. They were taking a substance that made them better to perform. That's performance enhancing. Finally, the ones that you read a lot about is the personal conduct procedure, where a guy, right now we're dealing with a couple, and the wide receiver in Oakland who did it, who was driving 159 miles an hour, and Deshaun Watson, who has 23 cases of sexual assault that's pending, and those are handled under the personal conduct. The NFL has historically been extrajudicial. They've gone outside of where before a court decides and will impose discipline. So that's going to be interesting in what happens there. So I was trying to run through that really quick because I wanted to see if we had any questions. And I kind of wanted to ask Bob Lattenville. Bob, we mentioned mediations, and you do some contract negotiations. Do you think mediation would be an effective method for contract negotiations? I remember talking to a friend of mine, the general manager of the Jets at the time, and they really wanted to do they wanted to do a new contract for Darrelle Revis. They both agreed that he was underpaid. And I said, why wouldn't you use mediation? And his response was, I'd love to, but the agent doesn't want to do that. Do you think it would be a good process?
I do. I do think it'd be a helpful process. I know, particularly with regard to, and I know who you're probably talking about, the NFL executive. But one of the biggest challenges that they have is with regard to coaches' contracts, because unlike the circumstance that Hal had mentioned, whether it's one of our big four, the NFL, the NHL, the NBA, or Major League Baseball, those uniform player contracts are available to agents as well as the team. So at least they've got the information. They know how much and they know how it's structured. In the context of coaching contracts, they don't have that information. And there's a host of antitrust issues beyond the scope of what we're talking about that prohibits them from sharing that information. And it's quite often that a team will get spooked into overpaying, or, for example, the agent may be spooked into getting less than what he was entitled to. And believe it or not, the level of sophistication at this point in negotiating some coaches' contracts is we'll take a look at what's published and try to determine the source and apply either a premium or a discount factor, assuming that the club's undershooting it and that the agent's overstating it. And for deals that, particularly like a head coach, that could be worth 10 figures a year, that's crazy, in my opinion, to base a contract on that type of information. Now, there are some opportunities, I think, to have a permissible carve out for sharing that information. But I think the mediator would be helpful in the sense it's not unlike a neutral verifier. It's like the agent maintains that there are 4 other teams that are interested in him. And I'm like, look, you may want to consider the fact that that's not true, or that you have other options. And again, I love the mediation from the standpoint of, at least in my experience, it brings both parties, including my own, back to earth. Like what's really going on here? What's the scope of issues? What is the magnitude from a dollars and cents standpoint of the issues we're dealing with?
Thank you, Rob. I see Mr. Litz has appeared on the screen. Does that mean our time is up, Rob?
That means your time is up. And Bob and Hal, thank you. A fabulous presentation. At some point, Bob, perhaps you could maybe email the answer to the following question that Hal posed in the chat, which is, can the NFL owners arbitrate their dispute with others within the NFL, such as Stan Kroenke's promise to indemnify? Interesting question. One thing I do know is that arbitration is all based on a contract. So if there is a contract between NFL owners, and Bob L., do you know if there is an agreement, written agreement between the NFL owners that they can arbitrate disputes between each other?
I don't. Well, I mean, I would say this: I've got the Constitution of the NFL behind me and the amendments, and I'm not aware of anything. That doesn't mean that it's not there. I've missed it, but I'm not aware of that.
Bob W.?
My understanding is that there is not a arbitration provision in the collective bargaining. I mean, in the Constitution and bylaws. And history has shown that owners will run to the courthouse much quicker.
Very good.
Right.
Yeah.
Although they do have some ways to deal with disputes among each other. Whether it's a employee club, or whether it's like in San Diego and there's another team that they're having, in Denver, they're having an ownership dispute on who can buy the team, and they're both using arbitration and mediation to try to settle that.
Great, great. Bob and Hal, thank you. A fabulous presentation. I'm going to let everyone go grab a cup of coffee. We're going to start in about 3 minutes. We're going to cover the clash of ethics, ethical obligations for advocates and mediators. So, fellas, thank you much, and we'll get started in just a couple of minutes.
Thanks, Rob.
Thanks,
All
Bob.
right, thanks, Al. Thanks, Bob.
See you, Bob.
Thank you.
Bye, guys.
Jim, I just made you a co-host for purposes of sharing your PowerPoint.
Okay, perfect. Thank you.
Got it.
So Jim, are you gonna run the PowerPoint for even, all the way through? That'd be fine with me.
That's fine.
All righty.
Let me do something here.
And Jim, are you leading off or is CJ?
I am.
Okay, all right. I'll do a quick intro and then turn it over to you.
And Jim, that we were talking about, that I'll just jump in if I have anything to add on anything, and otherwise I'm gonna be mostly doing the Zoom stuff at the end, right?
Yes,
Okay, no.
that works for you. It works for me. Can you guys see that okay?
Yes.
All right.
Well, folks, why don't we get started on our second program? The clash of ethics, ethical obligations of advocates and mediators. Questions come up often. What we can do when we're negotiating and mediating. We have two experts in the area. Jim Reeves, professor at WashU School of Law and mediator on our panel here at USA&M. And CJ Larkin, who has taught both at WashU and at the Denver University School of Law, very experienced mediator and joining our USA&M mediation panel. We're thrilled that both of you are with us, and we'll turn this over to you. Jim, I think you're in the leadoff spot.
Yes, sir. Thank you, Rob. Good morning, everybody. I hope everyone's doing well. Appreciate you joining us. CJ and I are going to be talking about some situations that sometimes come up in mediation. And we developed this program some time ago, just based on our experiences. When we started looking at the ethical obligations of advocates in mediation, and then also the ethical obligations of mediators. And some of you may not even be aware that there are ethical obligations of mediators. And sometimes these two ethical bodies, these rules come into, they clash a little bit, they collide, because there are certain things that lawyers are required to do under their ethical rules. And if they overdo it a little bit, overzealously, they want to get information outside of the mediation, for example, breaking confidentiality. And so we're going to talk about some of these scenarios that advocates can do that put mediators into a really difficult ethical space. And so we developed this to try and build awareness both on the part of the mediators in the audience, but also the advocates in the audience who, so we see, that mediation doesn't happen in a vacuum. There is this interplay between mediators and advocates. And so this next segment is about that interplay and how advocates and mediators can kind of bump into each other. So one of the first things I want to talk about, and CJ is going to chime in as we go through this also, and then CJ is going to take the driver's seat a little bit later on in the program to talk about some interesting things that have come up in the remote world, that virtual world of mediation, when we're doing mediation remotely, and some of the interesting ethical issues that have come up since we've been doing that for the last year and a half, almost 2 years. So one of the first things I want to talk about is what the, oh, I need my button here. There we go. What is the basis of some of these ethical rules? And what we look at is obviously the attorney and the advocates are governed by the rules of professional conduct, the model rules. In Missouri, that would, they start with the Rule 4 and then move on from there. And we're going to look at some of those specific rules in just a few minutes. Mediators also are guided by their own body of ethics. And you'll see on the slide, I use the word unofficially. The model standards for conduct for mediators may be adopted by particular courts, by particular states. I don't know of any states that have officially adopted these rules and tried to enforce them. However, they do exist. They are great guidelines for mediators. I will tell you, I serve on the ADR Advisory Committee for the United States District Court in the Eastern District of Missouri. And a couple of years ago, we considered whether or not to incorporate the model standards of conduct for mediators for the mediator panel for that court. And we debated it, we talked back and forth about it, and really decided, you know, it's going to be tough for the court to enforce those rules. In other words, who's going to do it? Is a judge going to start stepping in to try to govern the mediation behavior? And we decided, no, we're not going to do that. But we did put into the local rules that these are guidelines that we anticipate and expect that the mediators who serve on the court's panel will abide by these rules. And by the way, there is a copy of those model standards in your materials. You might want to take a look at those after the program, if you like. And I think they're very informative in terms of what the ethical guidelines for mediators are. There are also contract provisions. For example, USA&M standard mediation contract talks about confidentiality, talks about exceptions to confidentiality. And the parties are all required to sign these agreements, and the mediator is required to sign these agreements. That agreement follows Rule 17 in Missouri, the confidentiality. It also talks about that a mediated settlement agreement is going to be documented and signed by all parties, which is also required under Rule 17 for a mediation agreement to be enforceable. And then many mediators have their own agreements, but almost always there's going to be a provision about confidentiality, and also if there are going to be any exceptions to confidentiality, what those confidentiality exceptions might be. Another source.
I'm sorry.
Yeah, go ahead,
I
CJ.
was going to say that one thing I would add, and I don't know if this is like a statement against interest, but almost any time attorneys don't like what's happened in a mediation or say, I just don't, I have a problem with this mediator. What I found is almost always you could go back to the model standards and find within the model standards something that the mediator did or didn't do that the parties can say that's what it is. If it's self-empowerment, it's like they were way too pushy, they were bossy, they interrupted people. So it's not just, are you doing a great job? There are really ethical aspects to not doing your job right as a mediator.
Yeah. Yep, exactly. And then the other basis for ethical guidelines is state statutes and court rules. So, in Missouri, we have Chapter 435, which is part of the Missouri's version of the Uniform Arbitration Act. And then we also have court rules like Rule 17 that provide for competency of mediators, obviously confidentiality provisions, the requirements for documenting a settlement agreement that comes out of mediation, so it's properly documented and we don't have to look at the internal guts of the process in order to determine whether or not there's a settlement or not. There is a reference here in this slide to 4-2.4, And I want to look at that one a little bit because comments 2 and 5, I think, can be informative. And comment 2 of 2.4 talks about lawyer neutrals. Many of us on this call, and certainly just about everyone on the USA&M panel and a lot of the panels, are both attorneys and they are mediators or arbitrators. And our Missouri rules do cover the fact that lawyer neutrals are subject to disciplinary rules, that the model standards do apply to them. And so just because they take their lawyer hat off and put their mediator hat off, put their mediator hat on, it doesn't mean that, you know, suddenly with my mediator hat, I don't have to be ethical anymore. And or that those model standards for mediators apply to me, but the model standards for professional conduct don't apply to me. Not so. Not only do the models rules of mediators and for the professional responsibility rules apply, but also there could be other codes that apply, and some of those are listed here, one of which is the model standards of conduct for mediators. Similarly,
I would also add that, like, if not so many on our call today, maybe, but if people have are social workers, educators, etc.,
yeah.
They may have a whole other set of, you know, mandated reporter status, etc., that will change how they approach things.
Yeah, exactly. And a lot of, and that's a great example of social workers, for example, you know, they have their own code of ethics, and you're absolutely right. There could be exceptions to the confidentiality because they're mandated reporters. And that's a great point. Comment 5 under 2.4 talks about lawyers who are representing clients in alternative dispute resolution processes. Notice that it's very specific, that the rules of professional conduct do apply. And this rule also provides some provisions of candor to the tribunal. Now, cases I've seen, certainly judges are tribunals, courtrooms are tribunals, arbitration is tribunal. I would argue that mediators in mediation process is also a tribunal. And so there is a duty of candor toward those tribunals. And also under the rule, and we're going to talk a little bit more about Rule 4.1 in just a minute here, but there's also the duty to be ethically honest, that is, exercise a level of candor between parties as third-party negotiators. So we need to be aware of that as well, and we'll get into that in just a minute here. It's interesting because our model of mediation, you know, when I first started mediating 30 years ago, you know, there was a real mediation looked quite a bit different. We have a joint session. There was an opening statements. There was discussion about the issues that need to be mediated. A lot of the mediation took place in a joint session. And then perhaps we'd break up into caucus sessions and have private sessions. The last several years, of course, there's been more of a movement toward emphasis on caucusing, and there are mediators now and advocates now that say, look, we don't even want to have a joint session. We just want to go park ourselves in our private room. The mediator can go back and forth between the rooms. We don't even want to see anybody. We don't want to talk to anybody. We're just going to negotiate through the mediator. Well, that's really interesting because I think of this as, you know, it's the black box, okay? I'm an advocate. I am there with my client. I'm sitting in a room with my client, and those people over in the other room, we don't see them, we don't hear from them, we don't talk to them directly, and it's easy to psychologically just reject them. We can call them names, we can say whatever we want about them, we can talk about how awful they are, whatever that might be. I think of the analogy of driving on Highway 64. I'm in my car, I'm surrounded by 3,000 or 4,000 pounds of glass and steel, and somebody pulls in front of me and cuts me off without signaling. And I can say and do and hand signal however I like, because I know that I'm surrounded and I'm safe by all this glass and steel. I'm not going to interact with that other person. And so there's this safety in doing whatever I want. That person's no longer human. They're just awful drivers and I can call them names, etc. Well, the problem is mediation requires some interactivity. There's an interdependence between the parties if the case is going to get settled. There's a reliance. There's got to be a level of working relationship, if not outright cooperation, because both sides have to say yes to a proposal in order for the case to get settled. I find that bringing parties together in the beginning in some fashion is really, really helpful because it eliminates or at least mitigates that problem of, hey, if I don't see them, if my client doesn't see them, then we can call them whatever we want. We can think about them however we want. But it's a little difficult to really think that badly about somebody after you've met them, shaken hands, had a conversation. The lawyers will know each other. The clients, however, may not have an opportunity to meet the lawyers, say hi. I had a mediation recently where there was an insurance adjuster and he was there in the room and I brought the parties together. The plaintiff was a woman in her 30s. She came in, I introduced them all. We sat down, we talked for a few minutes. We talked about, was the case set for trial? I managed the agenda. So there wasn't going to be any back and forth. We weren't going to do opening statements, but I bring them together just to talk about some logistical issues and issues that we may need to overcome in the course of the mediation. We finished that joint session and I walked down the hall with the plaintiff and her attorney. And the plaintiff looked at me and she said, well, Mr. Reeves, that guy in there seems pretty reasonable. I thought he was going to be awful to deal with, but I think he's great. I think we're going to get along just fine today. Completely changed the attitude and the tone of the negotiations right out of the box. So mediation, especially through caucus, can create this ethically dangerous thing. It also puts the mediator as the primary communicator, which is also a scary place to be in the mediator because they've got to make sure that they're conveying messages correctly, that they're not making mistakes, that they're taking proposals in that are accurate. And this is what the party sending that proposal in is intending. CJ, anything you want to add?
Yeah, I would totally agree with you. And I think it's a very hard change. As a matter of fact, there's been some research done on the benefits of joint session, and it is significant. Doesn't mean you always have to, but it does. There are a lot of the things you're mentioning, Jim. There is some research that backs that up. I think the concern that people have, attorneys have, is my client's going to say something I wish they wouldn't. The other side is going to be so antagonistic that even if I was getting my client to a point where they might want to resolve this, now they're really PO'd. Two things I'd say too is I have seen attorneys who, rather than getting the other side's backup, I've seen, when you were saying that, I think that guy's going to be okay. I've seen that about the attorney and the client, where people said, I was kind of scared of whoever on the other side, but I can see they're going to try to be fair. Let's work with them versus I'm not letting that person railroad me, take $1 from me, etc. So, and I think you're really right about the dangers of caucus in that, and it's something I work on really hard because I think a lot of our practice is people maybe having a little bit of joint session and then they're both in their caucus for the rest of the time, is that you do a lot of script. I do something called scripting. I really just say, I'm going to say this. I'm going to say this because of this. I'm going to give these reasons. You want me to say this? I'll come back to you if they say something else. But meanwhile, I'm going to ask you some questions that I think they're going to ask. And if they do, I want to have the right answer. But that takes time, Jim, right? I mean, we have to, if you're going to go through all that and make sure that you get it right as their spokesperson, it takes some time. So I think in many ways, caucus is not as efficient if you think about it that way. You got to repeat stuff, the message sometimes gets, you try not to dilute it, but you might. And so I think my encouragement is if people could stay a little longer in joint session, maybe, I think it would be a positive.
Yeah, I've had situations where parties have just been, the lawyers have told me, Reeves, you cannot put these two people in the same room They're really angry with each other. And this is prior to the mediation, and my stock response is, okay, thanks for letting me know. We'll talk about it when we get there. And I've had 100% track record of saying, hey, look, we're going to put these parties together. And I'm not talking about the kind of situation where it really would be emotionally dangerous. I'm thinking of a sexual harassment case, for example. I'm not talking about that. But I am talking, for example, the brother and sister who are fighting over, mom's estate or something like that. We don't have that level of trauma involved, but we do have some really hostile feelings. And I've been able to develop processes that, we'll work on an agenda together. Okay, brother and sister, what do we need to work on here? What are the things, what are the issues we need to talk about? Just talk to me and talk to my whiteboard. You don't have to even look at each other. That's fine, but let's develop this. And, within a half an hour or an hour, we've got brother and sister who couldn't stand each other. They've developed an agenda. I congratulate them. This is great. This is what we're going to work on together. They've created now a joint document. And one session I'm thinking of is when we finished that, I congratulated the parties. I said, here's our agenda. And the brother and sister, for one split second, looked across the table and made eye contact. And I thought, all right, we're on the road here. So we're going to do that. So anything mediators that we can do to, we'll still use caucuses. I'm not anti-caucus, but just to be aware of the dynamic that pure caucus mediation can set up. The next thing I want to talk about specifically are the mediator's obligations. So these come out of the standard rules of conduct for mediators. Cornerstone of the mediation process is this idea of self-determination. Self-determination is a concept that distinguishes mediation from litigation, where judges and juries make decisions for parties. It distinguishes it from arbitration, where an arbitrator or a panel of arbitrator makes decisions for the parties. At the centerpiece of mediation is the idea of self-determination. The parties themselves have control over the outcome. They have lawyers there to advise them, to counsel them, to outline options, to explore the consequences of the various choices that may be available to them. The mediator is also there to take care of the process and help the exchange of information so that people can make informed decisions. But ultimately, self-determination is a key. And we're going to talk a little bit more about that, how that ethical obligation of self-determination on the part of the mediator can be eroded by some of the behavior of both the mediator, but also the advocate. The other thing that we need to be aware of is that mediators' duty of neutrality. And I would say also, it's not just a matter of actual neutrality, but perceived neutrality, meaning that the parties, the advocates, need to see and have confidence that the mediator is able to handle the case in a neutral manner, as humanly possible. I really make it a practice to talk to both lawyers prior to the mediation. And even if I don't have a lot to say to one party or the other, I might have gotten mediation statements prior to the mediation. I've read it. I know what the case is about. I know what the critical issues are. But I typically follow up with a phone call for each of the parties. I may have a very, very thorough pre-mediation statement from one of the attorneys. And I thought, I don't really need to talk to this person. I think I know everything I need to do. I call them anyway, because here's what I don't want to see happen is we get into the mediation session, either in joint session or comes out in caucus. And the lawyer says something to me like, hey, Reeves, as I told you on that phone call before the mediation, and the other attorneys going, hold on, you didn't call me. What'd you guys talk about? Are you keeping secrets behind my back? And even if the advocate is experienced to realize sometimes that happens, the client may not be aware of that. And it may raise some questions in the client's mind of, hey, how come the mediator's talking to the other lawyer and not you? What's going on there? So really maintaining that entire perception and reality of neutrality. The other ethical obligation or another ethical obligation on the part of mediators is to assure confidentiality. It's at the heart of Rule 17. That's why Rule 17 says things like, no, you will not bring in a mediator to talk about what happened during the mediation process. It is essential that that sort of shell, that dome of mediation confidentiality is in place, and the mediator is one of the people that needs to be able to enforce that and abide by that. We want to have an open forum that will be suitable for the exchange of information, which is essential to reach any kind of settlement agreement. That's essential to negotiation, at the heart of negotiation. And so we want to be able to have that free exchange as much as possible of that information. Related to that is the ethical obligation of quality of process. Now, I want to talk about that specifically because that may be something new that a lot of mediators don't know, and certainly advocates may not be aware of. But there again, the quality of the process says, look, the mediator needs to provide a process in which people can exchange information, they can talk, they can work together if they want to, they can say what they need to say. And ultimately, what we want to see happen is that the parties themselves, exercising their self-determination, are able to make informed decisions in the course of their case. That information exchange is critical, as I said a moment ago, and the quality of process is related to that, the ability to exchange information and be able to make informed decisions. So those are some of the key ethical obligations of the mediator. We'll talk about the advocate in just a minute. CJ, anything you want to add?
I would just add that the ABA has done a couple of studies of mostly attorneys, how they feel about mediation, what's been the success. And this first one was in the first decade, you know, a little bit prior to 2010, and there was another one in 2016. But an interesting thing that came out about in the first study of how lawyers feel about mediation is they said, we don't want cookie cutter mediation. And what they meant by that, as far as I can tell from the research, is we want to have some impact on the process if we want to. We want the mediator to be responsive to us and not to say, oh, I always do this. Oh, this is what we know. That's not what we're going to do. We're going to do this. So it is a idea that there's some interplay. I think that it's, you know, the mediator sometimes has to say, here's my concern about that. Right? Here's my concern about your idea. For example, in cases in which, for example, maybe one party doesn't want to do any opening at all, doesn't want to talk, as you say, you know, Jim, be in the other room from the beginning. That's an interesting reason, and they always have good reasons. Like what we're going to say is really just going to antagonize the other side. I think it's incumbent upon the mediator to say, okay, let me tell you my concerns. Here's what you lose in that process. You lose this, you lose that, you lose the other. Are you okay with that, right? So even though, you know, the mediator needs to be responsive, but it's also our responsibility as hopefully people who have the most experience doing this is to say, here's my concern. If you refuse to meet with them, I'm afraid this, that, or the other will happen. So is there some way we can limit your interaction with them? Is there some other way we can get some interaction between you? Because I'm afraid they're going to take that very poorly that you won't speak to them, right? And sometimes you can adjust.
Yep. Good. I want to talk now about the advocates' obligations, and I've boiled these down to just a few, but here they're showing up on the screen. And here, number one is to represent their client zealously. They've got to be prepared. They've got to be good advocates. And we're going to talk a little bit about overzealous advocacy in a few minutes and how that can impact the mediation process. Advocates are also under the ethical obligation to represent their client competently. That is, they're prepared, they know the case, they know the substantive area of law. This is something that they can competently advise their client and be the counselor at law as well as the advocate. And so that is one of the ethical obligations. Another obligation under 4.1, and we're going to talk about this rule specifically in a minute, is to avoid fraud. That is the misrepresentation of material facts during the mediation process. And that can get interesting, especially in caucus mediation. The ethical obligation also of the advocate is to protect the confidentiality of the client. Obviously, the communications between client and the attorney are privileged and they remain confidential. There have been times when I'm sitting in with one of the parties in caucus and their attorney, and we're talking about proposals, we're talking about the case, and then suddenly the advocate will start talking to the client as though I'm not there. And it was just this conversation that would just kind of slip into a part of the conversation. I'm thinking, I'm not so sure I should be here. And I will interrupt and say, hey, advocate, is this something you want to talk in private? I need to leave the room. Because having the mediator there does break that privilege, even though within the room that caucus is confidential. And so I'm very aware of what the client and the attorney are talking about. And when that conversation starts to turn into, this might be something that I don't want to come into my ears. I want to help the advocate to preserve that confidentiality with their client. And then there's also, like the mediator, the advocate's obligation to protect the confidentiality of the entire mediation process. That is, what's said and done in mediation remains in mediation. It doesn't go outside of the walls of the mediation unless that is agreed to in writing. I would require that agreement to be in writing. There are times when there are people outside of the mediation that need to be advised of what the outcome of the mediation is. I do a lot of workplace mediation, employment mediation, and sometimes there are supervisors or somebody else in an organization, someone in HR, for example, that isn't a participant in the mediation directly, but they may need to be advised because they're going to help implement the terms of the agreement. So we will have a specific conversation around who else needs to be advised of the settlement agreement. And we will write up a document or include it in our mediated settlement agreement, who those people might be or their positions, so that we can do that. But the advocate is required, just like the mediator, to protect that confidentiality of the process.
I would just mention one of my favorite cases. It couldn't have been favorite for these people, but it involved a school principal or headmaster who was in mediation. And there was, of course, all kinds of, because he'd been let go. And so there's all kinds of admonitions from the mediator, and I think it's from counsel as well, not that the settlement was strictly confidential. And it was, except for the headmaster's teenage daughter got on Facebook and said, can't say what happened in mediation today, but we're going to Europe for a month. Thank you, such and such school district. So anyway, so they lost that. I mean, there was all kinds of challenges. They tried to pin it on the mediator. Well, the mediator didn't explain to us about confidentiality, and that kind of went nowhere. Then it was, did the lawyers explain well enough about how third parties shouldn't say anything? And I think they ended up going back to mediation and getting a lot less money, unfortunately. So it's something everyone needs to be careful of.
All right. Okay, next, let's talk a little bit about self-determination. I told you I'd come back to this. I'm coming back to it right now. This idea of self-determination, and simple rule. I think we have just about everybody on this call perhaps has heard of that case or been participant in a case in which the mediator and or an advocate really wants to get the case settled. And there are, and things get a little bit coercive. The poor client sitting there, they don't quite know what to do. They're undecided, or they're just being difficult to work with sometimes. They're just being stubborn in some people's eyes. And they're saying no to every proposal, and then the mediator and or their attorney start getting really coercive, start twisting the arm, so to speak, and essentially talk the client into a settlement that the client doesn't want to enter into. And to me, there is some line, and I can't define it. It's the old, I know it when I see it. There's a line that gets crossed that says this client is no longer able to exercise self-determination. This is not their choice. It is the choice that they are making because they feel forced into making the choice. There are cases on the books where particularly lawyers have gotten sued by their client for that very behavior, for essentially coercing a settlement agreement. And it doesn't fly. It's not ethical. And the real practical import of this is like anything. Nobody likes to be forced into stuff. And when a client is, they wake up the next morning and say, no, I have buyer's remorse. I didn't want that settlement. I'm not going to stand by that settlement. And I'm going to call my lawyer and say, forget about it. I'm not doing this. And so we need to be really careful. And the mediator can play a real role in this. Hopefully they're not playing a role in that coercive tactic, but they can also talk with the attorney, I would suggest private, and say, hey, you know what, let's tone this down a little bit. Because my fear is that your client's going to say yes to a proposal they don't want to. And we're going to be right back here, or you're going to be back in court challenging the settlement agreement. So be careful. CJ?
Oh, does the next slide talk about self-determination as far as information, or shall I jump in here with that?
About what?
About information, how this can, well, let me just say it, and then if I'm ahead of our slide, I'm sorry. So I think one thing that's very tricky for mediators and can be for attorneys to sort of understand where we are, if we are aware of some significant information gaps or that's being withheld that would keep the party from being able to make a, you know, what is the phrase, knowing involuntary decision, that we can be put in a very bad ethical situation. So that is one of the frequent uses or impacts of standard one is if I don't know, make this up, you know, you have a bank account in Switzerland or something, and that's germane. And it puts the mediator in a position of this person, the other side's making a decision based on a total lack of information that is either here or could be discovered. And I now know it's an issue. What do I do with it? I think it puts the mediator in a really hard position. But if they know about the Swiss bank account, which the other party doesn't want them to disclose, understood, then the mediator sitting there saying, I know there's another $100,000 somewhere, right? So that I think that is maybe a subtlety that I think sometimes attorneys struggle with is, why is this causing you a problem? I have never, knock on wood, had to recuse myself or had to stop, you know, a mediation, but recognize that the mediator could be in a position where they feel like someone doesn't understand something at all, right? Or that there's a fact missing, and that puts us in a position of, what do I do with this? You know, if my job is to power balance to some degree, particularly if there's counsel and then not counsel on the other side, you've got neutrality, you've got confidentiality, a lot of issues. So yeah, information gaps are problematic.
Yeah. It's also a quality of process issue. And, you know, and while we're talking about this, now we don't have a specific slide about this, but we also run into this, and many of us have done mediations with pro se parties. And, you know, their exercise of self-determination, it becomes a little tricky because they don't have an attorney to advise them. And there are, under the model rules of professional responsibility, there are particular rules that require the mediator, the lawyer mediator, to be really clear with pro se parties about the role of the mediator. The mediator's not representing that pro se party. They're not advising that pro se party. And that's got to be a very specific conversation. And so, the best that the mediator can do is say, if you don't know what you're doing
I think.
and you don't know what
Jim
decisions to
pause,
make
or is
here.
it mine?
I'm sorry? Are we on?
You paused for a second there, Jim.
And so, and if the mediator is, so the mediator's there with the pro se party, and they are, they have to be very specific with that pro se party about what the role of the mediator is. Also goes into self-determination. And so it's a sticky situation for the mediator in that situation, but there are rules of professional conduct that cover that as well. I want to talk a little bit about neutrality. And this is a fun one. I remember, and CJ, I don't know if you remember that, I think you and Mike Geigerman and I did a presentation up in New York City for the ABA several years ago, similar to this. We all had horror stories about the overzealous advocacy and the behavior of lawyers in mediation, sometimes in joint session, a lot of times in caucus. Look, the mediator is just the piano player. They are the messenger. They are interacting actively with the parties, but the proposals are not theirs for the most part, unless they're asked to give a proposal in the form of a mediator's number, for example. But when the mediator comes into the room and provides a proposal, and the party receiving that proposal is frustrated, they're angry, they're upset, this is a waste of time. But sometimes it goes beyond that. And there are horror stories of advocates calling the mediator names, using anti-Semitic remarks, using saying horrible things to the mediator. Well, the problem here is that the mediator is human. How is that going to impact their neutrality? Now, when that's happened to me, a couple of things has happened. One is I stop them. If it's appropriate to take them out of the room away from their client, because I don't want to scold the lawyer in front of their client unless I think it's going to be effective. I want the client to understand that that behavior is not appropriate. But sometimes I'll do it, usually I'll do it privately with the attorney. And I will be very specific with them. Say, look, I'm okay to continue this mediation, but that kind of behavior is not going to work. I know you're advocating for your client. You have the ethical duty to do so zealously. However, you have crossed a line. So do we continue this mediator or mediation, or do you want me to go ahead and get somebody else to do this? Which means we're going to stop today. You'll find another mediator. I'm fine. I believe that I can be neutral. I want to make sure that you believe that I can be neutral also, and that you're going to agree with me that this behavior is going to stop.
Jim, I think it's always, to put, I always think of this in the positive for lawyers in the sense of try to be, it's not going to hurt you to be likable to the other side. And I have seen people not like the client, but like the client's lawyer and have been softened in their response. And I think that it's a fine line for advocates, and not so much attacking me, but attacking maybe the other side, is what you're saying, maybe your argument at trial, and what you're saying may be true, but can that person sit there and have you decimate them and still be willing to settle with you? So that mindset, I think, sometimes people talk about there's litigation counsel and there's mediation counsel, and I know you can't always have both, but I think that it is, you can still be tough and lay out your case. But if it, and I think it's fine for the mediator to coach someone, like Jim, when you say you take them out and say, don't talk that way. I have taken people out and said, did you notice so-and-so on the other side? They totally crumpled up. Their lawyer's writing them notes furiously. I know you want them to understand what your position is. I think you might want to back up and do this or do that. And this person's worked for you. It was an employment case I'm thinking of. This person's worked for you 20 years. You had mentioned to me the first 10 were great. Why don't you acknowledge the first 10, but just say, look, here's a nice summary of what our concerns are and why we had to terminate, whatever. And sometimes people just don't. It's a very difficult thing for a mediator to do because you don't want to tell somebody how to practice, right? On the other hand, if you clearly see it's undermining them, so it's not you're being a bad person, lawyer, it is, I think this is going to undermine your settlement. Whereas I know you're trying, you're trying to state your case.
Yeah, it's hard to listen to somebody when they're screaming at you. All right. I want to talk about confidentiality, the media's obligation, obviously, and the advocate's obligation, and we'll talk about advocate in a minute, is to maintain the confidentiality of the process from outside parties. I'm not going to say a lot about this. This is where this becomes an issue is when outside parties ask about what happened in the mediation, or one of the parties or more of the parties wants to share information with outside parties. And as I said earlier, there's got to be a very specific conversation about that. If it happens without some agreement, it puts the mediator in a difficult spot, because the mediator is there to protect that confidentiality. And often what happens is, if mediation information is leaked outside of the mediation without people's consent, the other party really, I've seen them get explosive. It gets really nasty. And so what we want to do is make sure we're preserving that confidentiality. This can be as simple as one case in which I had a young lawyer who was an associate in a firm handling a mediation. They did a great job. And after the mediation, maybe the next day or so, I get a phone call from one of the shareholders in that firm. And they said, "Hey, you mediated a case yesterday with, we'll call him Steve." And I said, "Yeah, I did. It was nice to meet him. I hadn't run into him before." And he said, "Well, how did he do in the mediation?" And I said to the partner, I said, "I can't talk about his behavior. I'm not going to talk about anything in there. I can't do that. It's a confidential process. I wish I could tell you, but I can't." Now, maybe that's a little bit too conservative in terms of protecting that confidentiality, but I tend to be really protective of confidentiality. The partner wasn't very happy with me, but they understood. They get it, but it can be as simple as that. CJ?
I had the exact same thing happen. And I think it's very difficult, because I would have only said great things about this person, but I just felt like, and then they're going to say, "Did they handle this issue? What did they say about this issue?" No, thank you. No, thank you. And we get this, Jim, we get this from judges. I've had judges ask me. I've had when parties have representation, but attorneys aren't in the mediation, it's really difficult, because then they may say, "So how did the other party act? I think they're really aggressive. Were they?" So it's just an uncomfortable thing. And I take the same tack you do, Jim. I really think I just need to preserve all that from people's imagine the face of the person and who they're asking about. And I don't think they really want me to talk about this whole thing. So.
Yeah. Yeah, and remember also when we talked a few minutes ago about court rules impacting confidentiality and that sort of thing, in the Eastern District, for example, there is a local rule that requires the mediator to report outside of the mediation process, whether the case was settled, whether the parties appeared with appropriate authority, and whether the parties and their attorneys participated in good faith. But that's in our settlement, it's in our mediation agreement. And I also talk very specifically with the parties and the advocates about that exception to confidentiality. So there are a few exceptions.
Yeah, and I think the EEOC format also requires that the outcomes are reported in the aggregate, not attached to the people. So I think anything goes. If you say the word elephant, I'm going to report it. As long as you tell them ahead of time and they agree to it, I think it's okay.
Yeah. So I want to talk about fraud for a few minutes. I want to be mindful of time also. I have a couple more slides here, but let's make this simple. It's not okay to commit fraud during mediation.
There you go.
Got any questions? So what we need to do, and here's the problem, especially in caucus mediation, is we have the mediator going back and forth. Some piece of information happens in one of the caucus rooms. The mediator becomes aware of it. It could be any number of things. It could be a critical piece of a critical fact, the fact that a witness has died and the other lawyer doesn't know it. Any number of things that the mediator can become aware of. And it could really impact the ability of the other party to make decisions. It could be a material fact. But the party giving that fact says, don't tell the other party this. Don't tell them this. I want you to keep it in confidence. And my response to that, and it really puts the mediator in a difficult place because A, they're stuck in the dilemma of, I am required to preserve the confidentiality of this caucus, but I am also obligated to provide a quality of process, and I'm also obligated not to allow parties to commit fraud. So it's really a sticky situation. Typically, what I will do is I will have a conversation with the advocate giving me that piece of information, and I will say, look, for now, I will keep it confidential, but it may be a time when I'm going to disclose it. I will talk to you first about it, because here what might happen if we don't disclose this. You still have control over disclosure, but I want you to be aware that I'm not comfortable with it right now. And there may be a time I'm going to come back and I'm going to ask you to go ahead and disclose this piece of information. And I've never had any pushback from any attorneys of that. They may not even be aware of the consequences of that decision. So I will have that very specific conversation with them. CJ, anything to add?
No, I agree. I've had that too.
All right. The comments in Rule 4.1 are really interesting because they do go into a little bit more about material facts and not only the failure to disclose material facts, but also misstating material facts. Not okay. It is fraud, and the mediator cannot be a party to that. The comments under the rule are also interesting because look at the second sentence here. Under the generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact. This is really interesting. Can you lie about your bottom line? Yes, ladies and gentlemen, you can. Is it ethical? Yes, ladies and gentlemen, it is. That's not a problem. I don't ask people's bottom line because one of two things is true. One is I don't want them to get attached to a particular proposal or number in their mind. I don't want them to get locked in there and then have to lose face by moving off that number. The other thing is I kind of assume they're going to lie to me or at least mislead me. So I don't even ask. We just mediate. We continue to negotiate. But be aware there are some carve-outs under the ethical rules for negotiation, which I think is really fascinating, by the way. And then this next slide leads into something that CJ said a few minutes ago about the communications between attorney and client, where clients in their representation withhold information, when attorneys withhold information from their client and the mediator becomes aware of it. A very scary place to be as a mediator. So this open communication between attorney and client is essential. And there have been times where, again, I've had to take the attorney out of the room, have a private conversation with them and say, look, this piece of information needs to be disclosed. I would be glad to help you facilitate that conversation, but your client needs to know that the statute of limitations has run. Your client needs to know that there was a mistake made in some of the decisions in the advocacy that you made, i.e. there's legal malpractice here. We don't frame it in terms of legal malpractice, but the client has the right to be fully informed about that representation. And when the mediator gets stuck in the middle of that, it creates some horrible ethical issues for that mediator. CJ, anything else?
No, that's good.
All right. Finally, duty to report. Attorney mediators, be on guard because and I got this right from Alan Pratzel, Chief Disciplinary Counsel mouth a few years ago. And he was asked directly, hey, Mr. Pratzel, do attorney mediators who were responsible for confidentiality still have the obligation to report serious unethical behavior on the part of an attorney? His answer was, yeah, I do believe they are. So that is an exception to the confidentiality. Just because we are in mediation, a confidential process, does not mean that attorney mediators cannot report serious ethical misconduct on the part of the advocates. All right, CJ, I think the next one is going to be yours. Let's talk about Zoom.
And if you can, I don't think I have the finger on the pulse, so if you'll just turn it when it makes sense. So these are added. I don't think this maybe were in your original packet, because we got to thinking about ethical impact of being on Zoom. And here's just a couple of things that we want to talk about. And that is that being on Zoom can create confidentiality issues, which you would not have in someone's office, and quality of process issues as well, right? So I think it would be great to actually talk to the parties and certainly their counsel about, hey, here's some concerns. But I've also, I think the next slide is some of the language to maybe include make sure you have it. You probably already do, y'all, because you're dealing with Zoom. But this basically says it is very clear, right? We agree that only the parties and their attorney, any third parties, have to be agreed upon in advance, which is also often people saying, oh, well, my wife's right here, right? Well, I'm not so sure is she a party? No. So that whole thing of getting that straightened out, and that people will not record it, audio or video, just explicitly say that. Make sure your language is in there to that effect. The next one is that a couple things I've had recently, they're like horror stories, as we said. Someone's video wasn't working, right? They could want the other party with their attorney. This person's pro se, they don't have, they can't be seen. Is it okay to go forward with the mediation? If it is, who has to agree? Do the non-video person have to agree? Do the other two sides have to agree? Does that create such a power imbalance and lack of due process, which when we talk about the St. Louis mediation project, when we're in court, we require that both parties be able to be seen. And if not, we schedule them privately for another time when it can happen, because it can go both ways. The person who can't be seen may have a lack of due process and total quality of process. On the other side, it may be the other person who says, I want to see them. I want to see their reaction, right? Can the mediator remedy it? Many times I've had people just waive it. They're like, they don't care. That's fine with them, right? But it is something. I did one the other day with this situation, and I had to say, okay, Sally, they're off Zoom now. They've been muted because they're talking to each other. Hang on. We have to do a lot of, sports casting, like on the radio, of what's happening because people can't see. Okay, next one. So in my mediation, I found out at the end that this was being done in bad faith. As we were just about to get off, they didn't recognize I could still hear. And I heard another party say, well, I'm glad you did it like that. And I would have told them this. Anyway, the whole time someone else was there. And I think that more and more people are not bringing their client into their office. They are having the client appear separately. And what is happening when they're at home, I think can be very problematic for everybody, all right? So it also can be sometimes that the people just have an emotional concern, like I just can't stand to see that person, domestic violence, etc. That's something to be dealt with as well. Now, any of these things, when I ask who can address, the mediator can address it, but if you're an attorney in a process, you may have a question about how it should go. This is something that happened to me the other day. If you do large multiple party mediations or lots of people, I do a lot of special education mediation where they use a drone camera. I made this up, I'm not sure. It looks like it's like a drone above them. You can't see the people's eyes, you can't see them talk. And people do that because if they're all in a big table in a room, you got like 3 teachers, 2 principals, and the district superintendent, and 2 lawyers, it's a little bit of a problem. You don't want feedback if they've all got their microphones on, but it's terrible process. People can't even see each other. I don't know who's speaking. In one case happened to me this way, where the parents had asked specifically for in person so that they could see their faces and talk to them. That wasn't possible. And so then we get a drone video. So see if there's some other way. And what we came up with was, you're all to be seen, but every other person has their microphone on so you can hear and speak without the reverb. Next one. This happened, talk about a nightmare. I was halfway through a mediation. people were, and one of the clients was at home and they said, oh, the nanny cam is on. And the other person has access to it. I'm like, oh no. So with Nest, you can, for example, videotape it and save it. So what do you do at that point? Do you stop and say, by the way, this may be being recorded. Can we undo that? Particularly if people are cohabitating, they probably have access to both. So what we came up with was everyone agreed to delete the video and that no one had watched it. They swore. Or keeping track of it. But I mean, that's the sort of thing you don't think of and you don't have to think about when you're in someone's office. Is that the last one? I'm not sure. I think we're getting
I think we got one more. I think this is the last one.
And this is probably the big confidentiality thing is whose job is it to monitor that? If someone's been asked, no, I don't want your wife participating, and then I go into caucus with them and I can see her shadow. Should the lawyer have stopped that? Do I stop that? What's the harm? They're going to tell their wife or their, friend anyway. But that I think both sides have a duty. I think the attorneys and the mediators have a duty to try to monitor that.
Okay. All right.
That gives us like a minute. There you are.
Yeah. Rob?
So I have one comment, Jim, that relates back to your points about confidentiality. And what I'm saying more and more is when a party knows they want confidentiality as part of an ultimate settlement,
yeah,
dropping that request at the very end,
yeah,
causes problems.
Yeah,
because often if it is a defendant who said, yeah, okay, we'll pay that amount, that's it, we're done. Oh yeah, we need confidentiality, and the plaintiff's lawyer will say, well, how much more are they going to pay for that? Yep. So putting your toe in the water early as an advocate that confidentiality is important, and then you'll work out the other details, the money, et cetera, I think smooths over a lot of problems.
Yeah.
I think it can be a strategy deliberately, like, well, we're all done. They're not going to balk at this. Let's just go ahead and go. But the reaction often is, well, that'll be an extra 20,000, right?
Right.
It
Right.
doesn't go so smoothly.
Well, CJ, Jim, thank you. This was a fabulous presentation for those who serve as mediators and those who are advocates. There's still open issues. I know what you said about Alan Pratzel telling us as attorney mediators that we have those ethical duties. It does raise some real questions.
Yeah.
Thank you both again. Great stuff.
Thanks, everyone.
So why don't we take just a couple of minutes, and Steve Ringkamp is going to get started at 10 after, and we'll finish up promptly at noon. Mr. Ringkamp, good morning.
Hello, Rob. How are you?
I'm well. Let me ask you a practical question. I know your materials are fabulous as ever. I have them open on my screen, and if you wish, I could forward to the page number so people could actually maybe see what you're looking at. Are you going to refer to the page numbers?
Yeah, I am, but I was going to refer to my page numbers.
Okay.
I mean, your page numbers, my materials start at page 50.
Okay.
But it's easier for me to say, okay, now on page 2 of my materials, which would be page 51 of yours.
Right. So what I'll do is I have your materials, and I'll refer. I see the same page numbers that you will. So like your ADR section starts at page 2.
Okay. Sure.
I think that may help them if they're looking for, if they don't have it right in front of them. It was all emailed to everyone, but I thought at least if they can see the site, if they're taking notes, et cetera. Okay.
That'll be fine.
Great. Great.
It's just that my materials do not lend themselves to anything other than what it is.
Well, the materials, as in the past, are absolutely fabulous. I'm hoping you had some help in putting this together.
Oh, sure.
Yeah.
You know, I did this for 40 years and Joan has taken over the bulk of it, Joan Lockwood. And so she deserves a lot of the credit.
Great. Great. Okay. Well, I'm going to go put a little more coffee in my coffee cup, Steve, and I'll be back in just a minute.
Okay, I'll be here.
Very good. Steve is a partner at the Holverson firm, has been there, I know, for at least 40 years, and I know a few years before that, Steve. And he has given of his time almost every year in coming on to one of our seminars to talk about key cases, civil cases in the past year. Steve has served on the Missouri Supreme Court civil jury instruction committee. I know for probably those 40 years, both as a member, as a reporter, and as the chair. And he does just a fabulous job. And what I'll do, a copy of his materials were forwarded when Kelly sent you the materials. I'm going to share my screen so that as he goes through, you'll be able to see on the screen the particular page where he's speaking from. Steve, thank you so much.
My pleasure, Rob. And thank you all for allowing me to appear before you, even though it is virtual, and share some thoughts with you about recent case law. Before I get started, I want to make sure everybody knows that there is a 8th edition of Missouri approved instructions for civil cases. Came out at the end of 2020. What you may not know is that this edition, and you can thank or get angry with West if you wish, is that it no longer comes with a disc that you can use to edit your jury instructions for your particular case. However, what you may not know is that available from West, and I don't think you need to have a Westlaw subscription. It's a standalone e-book, electronic book of the 8th edition, and the electronic version does allow you to edit or adjust or stick in names or print them out. So you really want that. I don't know what it costs, but I do believe it is a standalone version. The most important case that is not in the handout materials, of course, is the very recent Supreme Court case in which the caps on medical malpractice were upheld, at least with regard to the Article 1, Section 22A, right to trial by jury. It was upheld as constitutional, and that case is the Ordinola case, Ordinola, and it is 625 Southwest 3rd, 445. So if you have any malpractice cases and you have any questions about that, you can take a look at what was decided as well as what was not decided. A couple of statutes that were enacted in this last legislative session. There is Senate Bill 51 and 42, which I will refer to as the COVID immunity bill. There are actually many sections here involving liability for exposure to the COVID coronavirus. The bottom line is that healthcare providers are not liable unless the plaintiff can show either recklessness or willful misconduct by the healthcare provider in exposing a particular individual to COVID-19. The other statute that you will want if you get involved in any bad faith litigation, it also has to do with arbitration, at least in part, and that is House Bill 345. There is a section that affects section 435.415 relating to arbitration. And basically it says that an insurance company which refuses to participate in arbitration cannot be held for that reason to have acted in bad faith. The remaining sections of the bill deal with intervention in a case involving a section 537.065 agreement to limit execution as to a particular defendant. In other words, it gets settled. You all know what those are. My interpretation of these provisions still means, and I have a case that we'll talk about in just a few moments, still means that upon intervention, although that is not discretionary with the trial judge, the insurance company holds no greater rights during that intervention than the original defendant would have at that stage of the litigation. So if you get involved in bad faith litigation or any kind of section 537.065 negotiations, make sure that you read that, because there's a 30-day requirement to submit that agreement to the insurance company so that they can intervene. But you need to take a look at that and go from there. I want to give a big shout out to Joan Lockwood, who actually prepared this year's materials that I will be discussing. I have been doing this, as Rob said, doing an annual tort law review for various organizations since 1980. Joan has taken over the preparation of the materials, and this year's materials cover 578 Southwest 3rd through 620 Southwest 3rd. Now, obviously, the 98 pages contain quite a number of case synopses, and I'm not going to be able to get to all of that. You're going to need to take your time on your own if you have any particular sections that you're interested in. So the best I can do during this program is to hit the highlights. So let's start hitting the highlights with page 2. And this is alternative dispute resolution. The top case there is the Keeling case. What's important to understand here is that an order denying a motion to compel arbitration need not be designated as normal judgments, must be designated as with the word judgment at the top. Any order denying arbitration is appealable under the specific statute in section 435. The next one, I actually get a kick out of this case because I always thought arbitration was a contractual matter. But here in the Holm versus Menard case, the trial court involved some wrong kitchen cabinets. The trial court denied the motion to compel arbitration. But the appellate court said, well, now look, the lack of a plaintiff's signature on that arbitration agreement is not a sufficient basis for the trial court to deny the arbitration. A little kicker here is that on cross-examination at the hearing, the plaintiff did testify that he read the contract after receiving it from the store and before paying for the allegedly defective cabinets. So, you know, what's a contract? Does it take a signature? Well, in this situation, apparently not. Let's go to page 3. And this is one of those situations involving the Knight case. I'm going to skip the Pinkerton case and let's go to the Knight case at the bottom half of the page. This was a jet ski accident. The grandson, the defendants, entered into a 537.065 agreement and then voluntarily arbitrated liability and damages. And the important part here starts at the bottom of page 3, and that is under the 2017 changes to section 537.065, the Western District held that the liability insurance carrier has the right to intervene, but the law does not give the insurance company broader rights than the defendant. So once the arbitration determined the damage award, and this proceeding was to enforce the damage award in the arbitration, at that point, the insurer had the right to intervene, but didn't have the right to challenge the amount of damages. And importantly, the court held that the confirmation of the arbitration award in this method was consistent with the insurer's constitutional rights to due process, access to the courts, and trial by jury. So let's skip over to page 6. And at the bottom of the page, we have the Caldwell case. And just very quickly, this actually is a very complicated procedural history case. You might want to take a little time to read this summary over. But the plaintiff's employment agreement included a non-compete clause, restrictive covenants regarding confidential information, and an arbitration clause. Went up on appeal 3 times. But on page 7 at the bottom, you will see that the actual holding in this particular case is that the employer had the right to either go to arbitration or sue the employee. But the employee did not have that right. And so it was a unilateral right to make that choice. And what the court held was where the practical effect of the arbitration agreement binds only one of the parties to arbitration, it lacks mutuality of promise, mutuality of agreement, and is devoid of consideration. So that's something you need to check when you get into that kind of problem with an employment relationship. So let's go to page 8 with automobile cases. The first case is the Lee case, and I find that to be a very interesting case because the decedent followed another vehicle across a road which had been flooded. The other vehicle made it safely through the flooded road. Unfortunately, her vehicle was swept away. She and her child died. The Department of Transportation claimed that, look, a flooded road is an open and obvious condition. We cannot be liable because the condition of the property was open and obvious. The Court of Appeals said no. The extent of the flood of the roadway was not an obvious danger, especially since an earlier vehicle made it through. So the point here is that whether the circumstances were open and obvious, whether the decedent's actions in attempting to cross the road or cross the water were reasonable under the circumstances, including the depth of the water, the rate at which the water was rising, all of that is for the jury. And what you need to do with this case is anytime you have a premises liability case, even though this is in an automobile or sovereign immunity context, you need to have this case in your back pocket because you will want to argue that whether the condition is open or obvious is really a jury question and not a question for the judge. So let's move on to page 9. The Marks case at the bottom of the case. I also get a kick out of this one because the jury found for the plaintiff on liability, but assessed 0 damages. Inconsistent verdict. I trust you all know about MAI 2.06. When you get an inconsistent verdict, you send it back, and that's what the judge did properly in this case. So the judge sends it back for further deliberation. A jury comes back with a verdict of $1. And at that point, a couple of issues arose. One was that there was one of the jurors said, well, look, there were a couple of jurors on this during deliberation who said they just don't like money awards. And on that issue, the Court of Appeals said, well, that's really not an issue. It's an opinion. It is not an invalid expression of bias on the part of a jury. But on the issue of damages, the $1 was upheld. And the Court of Appeals said, look, simply because the jury agrees that there is liability doesn't mean the jury has to agree with the plaintiff's evaluation of damages. And if they want to say that there's only $1 worth of damages, they can do so. I find that a bit inconsistent myself. And had I been the plaintiff's counsel, I would have asked the judge to once again send the jury back, because that's just nominal damages. And I don't know that a jury has the right to award nominal damages unless they are instructed on that issue. Back on the juror bias or juror prejudice, the Court of Appeals said, look, plaintiff needs to show either that jurors gathered evidence on their own or made statements during deliberations demonstrating ethnic, racial, or religious bias or prejudice against a party or witness. That's fine and dandy. One of the things that I do want you to be aware of in the new 8th edition of MAI is that there is an implicit bias instruction. Actually, it's located in 2 places in the 8th edition. One is, first place is 2.00C, and the second is 2.03A, I believe it is. The first instruction on implicit bias is to be read to the jury before jury selection begins. But it is also to be used in printed form, and that's why 2.03 is in the book, in printed form along with the rest of the instructions at the end of the case. So you should be aware of that implicit bias instruction in this case, kind of tells you why. All right, let's move to civil procedure. I'm gonna skip over the section on choice of law. Let's move to civil procedure. Page 14, please. And the first case is at the bottom of the page 14. It's the State Exeter Country Mutual Insurance Company versus May. Wrongful death case. And there was a contract to limit recovery under section 537.065. The insurance company was notified of the agreement within the 30 days as provided by the 2017 amendments. Along with its motion to intervene, the insurance company asked for a change of judge. Once the judge grants, which the trial court really had no choice but to grant the intervention, and once a timely motion for a change of judge is filed, the insurance company is entitled to that change of judge, just like any other party. So let's move to page 17 and let's talk about the Furbit case. This is the latest case applying the Alec versus Vic Tanny case on exculpatory contracts, release of liability before the injury. Alec, of course, held that these were enforceable. And since all of these cases involving, all of the claims involving the issues here, while tubing down a snow and ice covered hill involved negligence, those exculpatory clauses were again enforceable. But note, there is a note here, and I want you to pay attention to that, because since all of the claims here were for ordinary negligence, and Missouri law permits exculpatory clauses for those purposes, there is no protection under the Missouri statute or under Missouri law for reckless conduct or intentional torts. Okay, next is page 22. And it's still civil procedure. It's at the bottom of the page, and it's EM versus Gateway Region Young Men's Christian Association. And this is a very, very difficult case. I don't know that I can agree with the end result by the Missouri Court of Appeals for the Eastern District. 15-year-old student, female student, confided in a teacher that a gym instructor had pursued inappropriate contact or sexual relationship with her. The teacher had an obligation under the Missouri child abuse reporting requirements to report that sexual misconduct. The teacher did not. And of course, the minor plaintiff sued after she was sexually assaulted and raped by the gym teacher. And the trial court dismissed the case on the grounds of official immunity, but granted the motion to dismiss based upon the public duty doctrine under the child abuse reporting laws. On appeal, the dismissal was affirmed and held that the duty to report the sexual harassment was one owed to the public. And so the public duty doctrine precluded the lawsuit against the teacher and the school. Now, if you look back at the Southers case, which you'll see cited on page 23, about the middle of the page, the Southers case does recognize an exception to the public duty doctrine. And that is where there is a ministerial duty in which an injured party has a special, direct, and distinctive interest in the enforcement of the statute, that there can be exceptions to the public duty doctrine. The Court of Appeals did not look at that or did not proceed to that evaluation. So that's the basis in which I question the continued viability of this particular case. Let's move to page 28. And I know I'm going to get this wrong. It's Green versus Footingham on the bottom of the page, page 28. And here, a plaintiff in a mobile home park filed a lawsuit against some other mobile home occupants in the park, alleging that they had set the mobile home on fire. One of the defendants filed a late response to the motion for summary judgment, citing Fifth Amendment rights to remain silent. Well, that doesn't really work because that defendant, while the defendant claimed that there was some factual disputes contained in the depositions, the Supreme Court, consistent with prior cases from the appellate courts, said, look, we're going to affirm the grant of summary judgment here. Number one, you were late. Number two, you can't just throw all the depositions in front of the judge and say, here, you find where the conflict is and the factual dispute that precludes summary judgment. There must be compliance with Rule 74.04. And those of us who have faced summary judgment motions in the past know that we have to be as meticulous about responding to summary judgment motions as the movant has to be in proposing a summary judgment. And the bottom line is that the trial court is not responsible for reviewing the whole trial record and all the depositions or even multiple depositions to figure out where the problems are in terms of factual disputes that create a genuine issue of material fact. Let's move to the damages section at page 35. And we'll start with the Roden case. The Roden case is one of the instructive, perhaps the most instructive case on the issue of aggravating circumstance damages in a medical malpractice case. The evidence here is basically that the physicians at the hospital ignored another physician who warned that the plaintiff's bladder had been perforated, causing an internal leak of urine. The patient ultimately suffered acute kidney failure and died. The case was affirmed on appeal because apparently MAI 10.07 was used to submit the medical malpractice standard. And of course, we all know that aggravating circumstances in a death case are the equivalent of punitive damages in any personal injury case. MAI 10.07 submits that the defendant's conduct showed complete indifference or conscious disregard for the rights of others. The medical malpractice statute says that punitive damages may only be awarded if the defendant's conduct is willful, wanton, or malicious. Note the disjunctive in that statute. Well, the majority of the Supreme Court didn't have a problem with the punitive damages or aggravating circumstances damages in this case, didn't have a problem with the use of MAI 10.07. But I want you to note that Judge Fisher disagreed with the principal conclusion or the conclusion of the principal opinion and said those two standards, the one in MAI 10.07 of complete indifference or conscious disregard, is different from, qualitatively, from the standard in Chapter 538 for punitive damages, which is willful, wanton, or malicious conduct. Interestingly, I mentioned that this is in the disjunctive. If you look up the dictionary definitions, and there are no definitions provided in the statute itself in Chapter 538, if you look up the dictionary definitions, willful and wanton kind of mean the same thing. You might think that malicious means the same thing as willful or wanton, but if you look at the definition of malicious in MAI, you'll see that it simply means the doing of a wrongful act without just cause or excuse. Can that definition of malicious in MAI be used in this situation? If you submit willful, wanton, or malicious, do you have to submit all of them? Or can you just stick with malicious in your modified punitive damage instruction? I don't know the answers to those questions. I know what I think, but I'm not sure that means much because it's going to end up on appeal if you prepare your instructions properly. Okay, let's move to page 37. This is Moore versus bi-state. If you've got any cases against bi-state, you really have to be careful because you know it's a compact, it's a creation of a federal compact statute. It's an agreement between Missouri and Illinois to create Metro, or bi-state development agency. Both are carriers under the federal motor carrier safety regulations. In this case, the Missouri Supreme Court applied the sovereign immunity caps contained in Missouri's own Chapter 537.600 et sequitur. The federal regulations require a $5 million insurance capacity on the part of a motor carrier. The holding in the case is, well, so what? It doesn't matter what the federal safety regulations require. We are still going to apply in Missouri the cap that is contained in Section 537.610. Now, the reason I say you got to be a little careful is because anytime you're dealing with bi-state or Metro, because they are compact agencies, the typical 5-year statute of limitations for personal injury does not apply. In fact, Illinois has a 1-year statute of limitations, And the compact itself, if you go look it up, if memory serves, has a 2-year statute of limitations. So don't get caught on the horns of that dilemma, or you'll be sending a letter to your insurance carrier. Let's take a look at discovery on page 40. The top case is the Hook case. The motion judge in the city got really upset with the defendant and held and wrote that the defendant engaged in contumacious and deliberate disregard of the court's authority, ordered compliance with discovery measures. Plaintiff awarded $5,000 in attorney's fees. And the motion judge also struck the defendant's pleadings and affirmative defenses. Now, that didn't mean that the plaintiff didn't have to prove liability. Ordinarily, if that's all the order says, liability still needs to be proven. Well, the trial court went back and said, nah, I really intended that liability be determined by my motion for sanctions. So we're only going to try this case on damages. And it resulted in a $1.2 million verdict. So up on appeal, the defendant says, wait a minute, there's an order and the judge can't change it. Well, the Court of Appeals said, oh, well, of course the judge can, because it's simply an interlocutory order. And any interlocutory order during the course of a case, be it a denial of change in venue, be it a denial of a summary judgment, or be it imposition of sanctions, the trial judge does have the authority to go back and review that order and change it. It can be substantively amended, reversed, or vacated at any time before the final judgment. So Rule 61.01 and 74.01B authorize the trial court to modify an interlocutory discovery order. Page 51, the Scherer case. This is a medical negligence and product liability case. Everybody, you really need to pay attention to this case, because the Supreme Court here clarifies how abandoned pleadings can, or more importantly, cannot be used as an admission on a party opponent. Because bear in mind that the rules of civil procedure allow a party to plead inconsistent or contradictory facts in the alternative. Here, the plaintiff made initially claims for medical malpractice against some healthcare providers, settled with those after amending the lawsuit to bring in the manufacturer of the surgical mesh sling, which is the subject of a lot of litigation. And so the defendant manufacturers were joined. The case was settled with the healthcare providers. And the trial court allowed the manufacturers to put into evidence as admissions on the part of the plaintiff the information that, well, there were these prior allegations in the original petition saying this was the fault of the healthcare providers. And if you look at the rest of the summary on page 52, you will see that the Supreme Court held that inconsistent pleadings are not admissible as admissions of a party opponent or inconsistent statements of a party witness, specifically finding that there is no justification for the application of the ruling that inconsistent pleadings are completely appropriate in a lawsuit. So it doesn't matter whether they're live pleadings or prior pleadings, they cannot be used as long as there was compliance with the rules on inconsistent pleadings. Another issue you might be interested in is that the plaintiff complained on appeal that the criminal prosecutions and pleas of guilty and convictions of one of the corporate defendants should have been admitted into evidence on the subject of, well, on numerous subjects. The point is that the Supreme Court held that section 491.050, which authorizes impeachment with prior criminal convictions, is not applicable to corporations. Not sure why, but okay. Let's move on to experts on page 57. And we'll take a look at the Rivas versus Bassman. This is another one of those impeachment cases, but it applies to expert witnesses. And one of the experts used by the defense in this medical malpractice case against an orthopedic surgeon had been extremely active on behalf of several organizations and in several states, attempting to enact tort reform measures, attempting to enact limits on damages in medical malpractice cases. But the trial court precluded the plaintiff from cross-examining the expert witness on those issues. And what the Court of Appeals said was, no, there should have been an allowance to challenge the defense expert's general and personal bias against plaintiffs in medical malpractice cases. So pretty simple holding. If a real renegade gets hired by either party, those personal biases, one way or the other, are the proper subject of cross-examination in a medical malpractice case, and presumably any expert in any type of case. Okay, let's move on to page 61. And we have the McGaughey case. This is an instructional case involving the Missouri Human Rights Act case. There are quite a few new instructions in Chapter 38 of the 8th edition of MAI. You need to take a look at them and see where they fit in. To your particular case, there are some, and pay particular attention to the notes on use and the committee comments in Chapter 38, because there have been so many changes to the substantive law on the Missouri Human Rights Act, even within the last 4 or 5 years, that what instructions apply to your case will depend tremendously on when the cause of action accrued. And there are certain cases that have been statutorily overruled, but may still apply to your case, depending upon when your cause of action accrued. One of the things that you will not find in Chapter 38 in the 8th edition is a hostile work environment instruction. Well, the importance of the McGaughey case at page 61 is that the plaintiff patterned the verdict directing instruction after MAI 38.01A, and the Court of Appeals said that's just fine. That holding took place even though the employer said, well, wait a minute. I thought we had to, the plaintiff had to show that the harassment or the hostile work environment was sufficiently severe or pervasive, that it affected a term, condition, or privilege of employment, and that the employer knew or should have known that the harassment was taking place and failed to take proper action. Well, you know, that's appellate court language. Not all appellate court language translates into a jury instruction. And the holding in this case is, again, you don't need to use all out appellate court language in the instruction in a hostile work environment claim. MAI 38.01A does the job. I hope. Let's look at the jurisdiction and venue, page 70, because I just want to point out to you that we don't normally include in our synopses of recent tort law for the last year. We normally don't incorporate US Supreme Court decisions, but we did this time because the Ford Motor Company versus Montana District Court is an important decision. It actually involves two cases, one in Minnesota. The accident occurred in Minnesota, and another in Wyoming, and the accident occurred in, or excuse me, Montana. The accident occurred in Montana. Ford Motor Company, based upon prior decisions of the US Supreme Court, said, well, no, you got to dismiss this because these are not substantial contacts sufficient to meet the prior decisions of the court, because the prior decisions of the US Supreme Court said that state courts have jurisdiction only if the company designed, manufactured, or sold the vehicle involved in the accident within that state. And the Supreme Court said, no, that's not what our holdings meant. And the plaintiffs could not prove those things because they were used vehicles. That were initially sold in other states. They went through a process of purchase and sale and ended up as used cars in those states where the accidents happened. Bottom line is, the state in which the accident happens is good enough. The last case I really want to talk about in the premises liability case, and it begins on page 80. You'll find this one to be a head scratcher because a plaintiff, a customer at a casino, entered a casino before any rain, snow, sleet, or anything else like that started falling. While in, it did snow and sleeted, and nothing was done. Slipped on the ramp exiting the casino. Casino did nothing to throw any salt down or remove the snow. The Court of Appeals said, well, we're going to apply the Massachusetts rule. And the Massachusetts rule says the landowner has no duty to remove snow or ice that is a natural accumulation and is a general condition existing around the neighborhood or the town or the city, particularly if the precipitation is still falling. So no case, no liability on the part of the casino. Applying the Massachusetts rule. Interestingly, Massachusetts threw out its own rule in 2010. Why would we adopt it in Missouri? I'm not sure, but there you go. I think I have a few minutes to answer any questions. I don't know. There's really a lot for you to get involved in here, and I hit the highlights as best I could. You may want to find some other cases involved here that are particularly important to you. So hopefully the summaries will help you. One final word about the annual tort law reviews. If you get involved in tort law civil cases, I would suggest that one way or another, you get your hands on these every year, because I've still got every one I've ever written. And I know where to find the cases that I may have forgotten about. And this is an excellent way for you to keep tabs of the law over the years. And as a matter of fact, I see a lot of judges with 10, 12, 15 years worth of these books sitting on the back of their desks. So make it a habit.
Steve, thank you. As always, fabulous materials, great presentation, hitting the key highlights. Certainly appreciated for those who don't want to wade through the full 98 pages, but I would recommend this is probably the best summary of what's going on in civil law in the state of Missouri, and certainly appreciate your expertise and experience. So Steve, thank you on behalf of everybody.
My pleasure. Thank you all for paying attention.
Folks, last thing from us, be looking on your emails for a notice to save the date. We'll be coming back to you with our next program in February. We thank you for participating. I know the Legal Services and the Cornboom Food Pantry and the St. Louis Mediation Project appreciate your financial support. And we wish, on behalf of everyone here at USA&M, you and your families a happy and healthy Thanksgiving and a terrific holiday and New Year. We'll see you in 2022. Thank you all.